Okay, I'm back here. Continuing on, I just finished talking about the scheduling conference order that Judge Mahler sent us. So I don't know if you remember within that order, it said that all motions must be in by January 20th in order to be heard at the February 22nd hearing. So we got in another motion, okay, which probably surprised them again, hopefully. So we got in another motion, and it is the motion to remove Judge Mary Mahler, to notify and refer the case to the Supreme Court, and a notice of removal of our case to the Supreme Court in accordance to 28 U.S.C. 1441 and 28 U.S.C. 1331. Okay, so we put in our motion. Here's the motion papers. This one. Affidavit in support of motion that always needs to go along with your motion. Our signatures, affidavit of service by mail. You need to fill that out too. And then here is the affirmative showing in support of motion to remove, disqualify Judge Mary Mahler. All right, this is long. I'm going to just take snapshots of it, kind of, so you can see slowly. I am not going to read all of this. I'm going to quickly go through some of it like I did in court. Okay, so these are the judicial codes of conduct for U.S. judges. There are canons 1 through 5. There may be more canons. I'm not sure about that. But the canons 1 through 5 were able to remove 2 judges so far. And we motioned to remove Mary Mahler. Okay? Canon number 1 is a judge should uphold the integrity and independence of the judiciary. At the hearing on December 21st, at the scheduling hearing, the first time we were in front of Judge Mary Mahler, she quoted Abraham Lincoln to us and said that those who act as their own lawyers are fools. I'd like to know what, I'd like to have some comments from our viewers to see what you think about that comment that a judge makes. First of all, it's politically based. And calling us fools, that does not uphold the integrity of the judicial system, to say the least. Okay? Canons should be applied consistently with constitutional requirements, statutes, other court rules, and decisional law. So we talked about how Mike has disabilities in this letter. He has never had the opportunity to have any accommodations in any court hearings in his whole life. As a special education teacher of 20 years, I realized that after looking at some of his history and seeing that he has not gotten a fair shake here. Mike has been discriminated for many, many years in many different instances. So here's just a couple examples that they have a pattern of discriminating Mike. They interrupt him while speaking. They tell him he doesn't have the right to speak everything that he wants to say, to express his views. They reprimand him for rolling his eyes, or if he laughs a little bit, shrugs his shoulders. Anything Mike does in court, they're going to nail him for it. I'm not sure why or what their motive is for this, but maybe it'll come out someday. I'm not sure. Okay, he has a First Amendment constitutional right, we all do, of freedom of expression and the right to be fully heard in court, and that is according to Canon 3A4. The most judges do not give you the right to be fully heard, and they cut you off, and they act like they are the ones in power at the time, but actually we all have some power if we can just think about the way that they're acting is inappropriate and unprofessional, unethical for their job title where they sit on their throne. Okay, so she laughs at us. Judge Mahler laughs at us. That's harassing, abusive, prejudice, and bias. She tells us that we need to do this alternative dispute resolution that I just talked about in that scheduling order. And actually, I cited a law that says that we do not have to conduct in that. Okay, where am I? Let me turn back to this one. Okay, under. Okay, sorry, I was talking about something else here. Okay. We have civil rules of procedure, timelines under Rule 55, default shall be granted. We demand the default judgment granted because in the past there were 3 other judges that filed a default hearing, that we were supposed to have a default hearing, and nobody ever saw that information, or we never had a default hearing for some reason, but it was scheduled 3 times. Okay, they should respect the law at all times. She interrupted us and said that she said herself that she had a snarky attitude towards us. She talked about a prior case that she presided over in the Court of Appeals. And according to Canon 3A6, you're not supposed to talk about other cases that you were involved in. She says she knows nothing about us being indigent or not. However, we filed and was granted in form of papyrus, and that it is in our court files. And if she would have read our files, then she would have known that. Judges are required to read the files before they come in front of us for the hearing, which she did not do. We talked about how this experience is causing us increased emotional abuse and pain. Our pursuit of happiness is gone. They have just destroyed it for us. Judge should perform the duties of the office fairly, impartially, and diligently. The way that she conducted herself was not fair and impartial. Mr. Wonderlick. Let's talk about Mr. Wonderlick for a minute, okay? He is showing up at all of our court hearings. Isn't that interesting? Mr. Wonderlick was my criminal attorney, criminal defense attorney that was appointed by the court, who threatened us and harassed us throughout our criminal cases. Now he comes to the courthouse when we're having our civil case, and he pops into the courthouse, walks in and smiles and looks at us and sits there and says, I can be here. He is harassing and stalking us, okay? This wasn't just the first time. This has happened more than once. Every time we come to the Morrison County Courthouse, he's there. So I think that he plans his court hearings on days that we are scheduled so that he can listen into what's going on. And we wonder if the court is actually even having him sit in another room listening to the whole thing himself. Okay. Not sure why they would do that kind of corrupt behavior, but it sounds like he seems to know what's going on, and he's happy to be there and listening to everything that's going on with our court case. We talked about videotaping our dispositive pretrial hearing, and we tried to bring our video camera in, and Dave Kicker said no, that we could not do that. Now, this is up to the judge, according to Minnesota Rules of General Practice. It's up to the judge to make that determination whether we can videotape our pretrial motion hearings. And it does say in the rules that under the exceptions that these hearings can be recorded and videotaped. Okay. They continuously make procedural errors, but then they draw attention to our technical errors and keep saying that we're doing something wrong. I'm sorry, I'm just kind of loosely going over this. Like I said, you can kind of read through it. And I was a little more articulate in court when I had to say this in front of Judge Mahler. I'm just getting tired of all of it by now, of course, as you can see. Okay, you can see she was disrespectful, cut us off many times. This is about the time sensitivity that we talked about. Here's all of her scheduling orders. Oh, that's what I was going to talk about. Okay. So we already filed for jury trial. We asked for jury trial many, many months ago. Okay, all the papers and things have been served correctly. We have dates of all of the proof of services. Okay, this is that alternative dispute resolution that I was talking about earlier. Okay, the fact is actually that Minnesota Rules of General Practice, inability to pay. If a party qualifies for waiver of filing fees under Minnesota statutes, sections 56301, or if the court determines on other grounds that the party is unable to pay for ADR services and free or low-cost ADR services are not available, the court shall not require that party to participate in ADR. So we have granted informa paperis. Oh, I'm sorry, guys. Informa paperis. We will not submit to mediation, according to Rule 114.01. Okay. We talked about that decorum. Okay. Here's an interesting court case. Okay, I'll just read this part to you. Once again, these are court rules that apply to professionals within the court system. A judge has no First Amendment right to belittle and berate litigants in her courtroom. The Washington Supreme Court ruled in ordering that a state district judge be suspended for 5 days without pay. Numerous complaints were filed against this Judith Eiler, a King County district judge since 1992. Centered on her treatment of pro se litigants, individuals who represent themselves without the services of an attorney. Okay, so this judge in New York years ago was disciplined for favoring attorneys and disfavoring or belittling and berating litigants who are pro se or their own attorneys. We stated how the Morrison County Sheriff's Department, Pierce Police, and State Patrol did not learn anything from George Floyd's death. This is an insult the way we've been treated by courts in the last 3 judges. Feels like the cops are standing on my throat all over again. I still can't breathe. Michael says, Morrison County is depriving us of our pursuit of happiness. The Declaration of Independence says, we hold these truths to be self-evident that all men are created equal, that they are endowed by the their creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of people to alter or abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to effect their safety and happiness. So I think we've heard that before in the Constitution, but we need to be reminded of that, and they needed to be reminded of that. So we wrote that in the recusal as well. Okay, we believe that she needs discipline herself. And in the affirmative showing of intentional prejudice, bias, and improper misconduct, Judge Mary Mahler must recuse herself or be disqualified from the case. We want to remove this case to the Supreme District Court. Okay, I'm going to end this one, get a drink of water, and then I'll get back to what happened next.